thank you for coming today, whether you're in the room or whether you're listening to this online. This is a presentation where we're going to discuss the proposed amendments to the Health Information Protection Act, which we commonly call HIPAA. We first proposed these amendments in June of 2016 in our annual report, and we entitled our annual report Striking a Balance. My name is Ron Krusniski. I'm the Information and Privacy Commissioner, and co-presenting with me today is
Director of Compliance.
When we were working on the amendments, and we had a number of objectives in mind, and we hope we've achieved some of them. And the first one was to reduce the timelines wherever possible. We believe that citizens should get their answers as quickly as is practical under all the circumstances. We also wanted to let our legislation catch up to what had occurred across the country. Sometimes Ontario introduces a piece of legislation and then Alberta improves upon it, and over 10 years, existing legislation gets a bit out of date. So this is the opportunity to let ours catch up. HIPAA was introduced in 2003, so it has about 13 years, and certainly other jurisdictions have moved forward during that time. We wanted to reduce confusion. Anytime you have legislation, words are used by the drafters that cause confusion, and wherever we could eliminate that by proposing an amendment, we wanted to do it. And of course, eliminate any barriers to people getting the information that they're entitled to do. Obviously wanted to increase accountability. Personal health information is maybe my most sensitive information that governments or trustees or organizations hold. So therefore, when I give people that great trust, then in turn, I want them to account and take care. Wanted to discourage snooping wherever we could. We certainly issued enough reports about snooping, and wanted to clarify the use of personal health information for secondary purposes. And usually those are where the person's consent is not being obtained. So basically, we hope the amendments were intended to strike a balance, or a new balance, between the right of access and the protection of privacy. And we hope we found some things in there that would help trustees or government institutions, would help citizens, and would help our office do our job better. So I'm off to item A, which proposed a purpose clause. Not all pieces of legislation have a purpose clause, but we think when you're dealing with quasi-constitutional legislation, as the judges have referred to it, that it is reasonable and justifiable to have a purpose clause. What can a purpose clause achieve? Well, it's certainly, when you go to read it, you can get a sense of what the legislators wanted to achieve, or what were their purposes in passing this legislation. It probably also helps any of us working with it kind of knowing generally what the MLAs wanted, and certainly helps judges when they have to interpret, section 16 or 29 or whatever, to have a sense as to, again, the purposes that the legislature had in mind.
The next is item B, definitions. What we found with working with HIPAA for almost 13 years now is that it's missing some key definitions. So in this particular area, we proposed either new definitions or expansions of existing definitions. There's also a ninth definition that will be coming up in another slide, along with some additional amendments that the Commissioner will speak to. But the first in this section is health services. If you look at HIPAA in a number of different places, it also just references services. It doesn't even clarify that what we're speaking to is a health service. So first and foremost, we want to clarify that, but also to ensure that there's consistency in Saskatchewan statutes, we have recommended that health services in HIPAA is the same definition as you would find in the Regional Health Services Administration regulations, which, if you're familiar with, it's a long list, but it really captures what health services are within the health sector. The second, and I've always found this a little odd, is though HIPAA defines collection and use, it doesn't define disclosure. So we've proposed a specific definition for disclosure. The third is when it comes to next of kin, because we know in different circumstances that can mean different things. We're dealing with collection, use, and disclosure of personal health information. So really it's about when it's okay to share with people that are related to you, whether through marriage or not. And so what we're clarifying is next of kin includes a long list of people, including parents, siblings, and others, not just a single designated person. The fourth is a definition of research. You can't imagine how many times we get that particular question. And also making it clear that what it does not include is planning and management of the health system. The fifth is, even though we already feel that the definition of personal health information includes genetic information, we want it to be explicit so there is no doubt going forward. The sixth is, what we have found problematic is there are circumstances where sometimes a non-trustee, whether it be a private organization or it's a municipality, actually has custody or control of personal health information. And they may even employ physicians. But at the end of the day, we don't have a trustee under HIPAA that has responsibility. And so the proposed addition to the list of who is a trustee, we're including a person who operates a facility whose primary purpose is the provision of health services provided by health professionals licensed or registered pursuant to an act. And we think that'll fill the gap. The seventh is making sure that the understanding and how it works in practice is clear in the legislation, that when you're dealing with employees, that includes a whole host of other individuals that are brought into the workplace that come into access with personal health information. And that includes contractors, information management service providers, students, volunteers, to ensure that everybody knows that they have to follow the rules and there's accountability in place. And lastly, record of user activity. It's not mentioned in HIPAA, but it's common practice when it comes to information systems that are out there, at least the newer ones, not necessarily the legacy systems. And it's critical in terms of ensuring accountability in the system. So we are proposing a definition and further amendments around user logs in item R, which I will speak to later.
We're off to item C, and it's called data matching. It can be titled under different things, and there's lots of articles about it these days. Data linking, use of big data, data analytics, just depending on which phrase you want to use. And clearly in government in the broadest sense, the public sector and the business sector too, we're really all shifting at a pretty rapid rate to databases and having our data stored electronically. And then what comes up is very quickly is if you have 1, 2, or 3 databases, if you can get some information from each, or maybe you can find something out about some current problem that exists that you think needs to be solved. And basically, you know, there is certainly lots of good problem-solving projects out there, but again, when you're using my personal health information, I'd like to see some limits and controls on how it all gets done. So HIPAA does not have any rules on this at the moment, and basically we were proposing that there be some rules around data matching. In effect, kind of copied the Alberta model, took their definition of what is meant by data matching, and basically, in large part, talking about ensuring that there's adequate protection and maybe an information sharing agreement, and always making sure that the trustee that's doing it has the authority, in effect, to do what they want to do.
Item D is consent. For those of you that are familiar, HIPAA contemplates 3 forms of consent. The first is expressed, second, implied, and third is deemed or no consent. And in this particular section, we were looking at 2 proposals. The first is making it clear that when we're reading subsection 26.3, that it's expressed consent that's required when using an employee's personal health information for employment purposes. And the second is with respect to subsection 24.4 of HIPAA, which gives a trustee authorization to collect personal health information for any purpose with the consent of the data subject. HIPAA already authorizes all of the primary purposes for which personal health information is needed in the system, and a whole swath of other secondary purposes, not only in the Act, but the regulations itself. So when it comes right down to it, this particular section we don't see as being necessary. So we're asking for it to be repealed.
I am off to the next item, which is item E, and it is the right to information regarding a disclosure that is given without your consent. And we just think if entities are keeping information about me and disclosing it without my consent, with authority, but that I ought to be able to ask and find out who have they disclosed my information to without my consent. And basically in a paper world, I guess you would keep track of it in a paper sense when you disclose information. In an electronic world, we're really suggesting it may be done by electronic logs or that type of thing. We do put in there that if somebody asks, they will be told when their information is used, if it is reasonably practical. And really that contemplates the legacy systems out there, that it may not be possible at this stage in their evolution or death to actually put in new logs and track information. But as they're regenerated as new systems, then it probably becomes very easy to do that.
Item F is exercise of right or power by another person. This one is very straightforward. There needs to be an amendment that makes it clear in subsection 56EI of HIPAA that it's the Minister of Social Services that is responsible in this particular case.
Next, item G is retention and destruction policies. Section 17 in HIPAA deals with this right now, although part of it hasn't been proclaimed. But we were basically proposing some amendments here that trustees have a policy for retention and destruction, and as a minimum, they have a 10-year destruction for personal health information. Could they have a longer period? Yes, they could, but as a minimum, they would have 10 years. Why 10 years? Under the Hospital Standards Act, that is what I think many organizations are working with right now. So it seemed to be probably a good one to put in here. In an earlier presentation, it was raised that for some government institutions, maybe like Sask Energy, that isn't in the health sector but has some personal health information, maybe it should be shorter than 10 years. So we were asking that person to write us an email, and when consultations take place later on, that certainly may be a factor here.
Item H is about researchers, and specifically if you look at HIPAA, it's section 29. So subsection 29.1 and subsection 29.2 of HIPAA, we feel should be amended to ensure that before researchers are provided access to personal health information, that they need to enter into written agreements with the trustee or the designated archive. With the amendments, we also are proposing that specific elements be included in those agreements and they become standard. Some examples of elements include not to use the personal health information for purposes outside the agreements, not to contact any subject individuals except as authorized by law, to take reasonable steps to protect the personal health information, and to notify the trustee or designated archive in writing immediately in the event that there's a privacy breach or a breach of the agreement. And again, we're looking for that consistency in language, that harmonization. And so for one of the examples we have, the language is consistent in terms of what is found in subsection 29.3 of the Archives and Public Records Management Act.
Off to item I, which talks about access. Now, under legislation, including HIPAA, if you ask for information about you, your health information, the trustee has 30 days to provide it to you. And our assessment of that is if you're in the hospital and you want to see your information, you're probably going to get discharged before 30 days are up. So basically what we're saying there, in certain limited circumstances, like being in the hospital, if you request your information, you can get it within 24 hours. That way it will be much more useful to you if you're actually receiving treatment at the particular time.
Item J is abandoned requests, and I think this one will be really popular because it's going to give you some advice as to when you can close your file if you're having difficulties with the individual. And this is consistent with what we proposed when we came out with the proposal for FOIP and LA-FOIP amendments in It's Time to Update, which is also available on our website. So specifically what we're looking is if you have to go back to the applicant to get further information, to even figure out what is it that they're looking for, or if there's a fee that is going to be charged. And in either case, if they're not getting back to you and you provided that notice in writing, within 30 days you can close your file. And the only hiccup in all of that is that they do have a right to request a review of our office.
We're off to item K, deals with third parties. A third party can be, I guess, almost anybody that contracts with a trustee. And, in a hospital, it could be, a laundry or a dietary service, medicines, whatever. And in general, the Freedom of Information Act, if we're reviewing a file, the third party has a right to give us a submission and say, no, we want this information released, or we don't want this information released. That hasn't existed in HIPAA, and we were just proposing, as a matter of fairness, that if there is a third party involved, they would have a right to make submissions to us and say certain pieces of information shouldn't be released, et cetera, et cetera.
Item L is about fees. And those of you that work with HIPAA know it's frustrating because there isn't a fee schedule. And often what we've done in the past is if you were a trustee that was also a local authority, it made sense, of course, to look to the LA FOIP regulations and its fee schedule, or if you're a trustee that was a government institution, maybe to look at FOIP. But there's a whole bunch of other trustees that aren't either. And in addition to that, we're moving away from paper-based record systems to electronic or digitized records. And so there should be a lot greater ease in which there is to find and to prepare these records for release. And so what we are proposing is specific provisions that first and foremost do allow for the trustee to charge for a cost of reproducing the record if in fact it would take less than 2 hours to do the search and preparation. But also that if it's going to be greater than that time period, that they can charge fees, which we have not yet spelled out, but would be spelled out in the regulation. But that if there's an estimate of fees given to the applicant and the actual cost is greater than the estimate, that consistent with FOIP and LA FOIP, you can't go higher than the estimate, and that there's an upper limit of $400. You can't go higher than that and charge the applicant more than that. And the other thing that's missing from HIPAA, which FOIP and LA FOIP does speak to, is a fee waiver. So what we're proposing is that there's some discretion that the trustee has to make a determination as to whether or not to waive the fees in a couple of circumstances. One, if they feel the individual cannot afford the payment, or secondly, for any other reason they believe it's fair to excuse the payment in the circumstances.
We're off to item M, and it's the duty of agents and employees. And kind of along the vein, we have a very large health sector, and it has a lot of players, and some of them are agents, some are employees, some are contractors, some are consultants. And basically, if any of those agents run into personal health information, we believe the duty to protect it should be the same as it was on the original trustee, and that the trustee, obviously engaging the agent, should make sure that things occur such as orientation on HIPAA for employees and agents, signing confidentiality agreements, and basically taking steps within the trustees organization and those that the trustee deals with to protect and safeguard that information. I heard a speech once, if you're going to collect it, then you're obligated to protect it. And I think that really fits here in whatever ways you decide to sort of carry out your business.
Item N is elements of information management agreements. Specifically, these would be amendments to the existing Section 18 of the Act. So just as we made the recommendation that when involving researchers, there should be written agreements with specific elements, very similar proposed amendments in this section as well when it comes to information management service providers. So it's really important in terms of consistency across the board that there's those written agreements with specific elements to make sure that that information is sufficiently protected.
We're off to item O, continuing duties of trustees. Trustees exist. Some trustees, if they're a small business, retire. Some move to a different province, and they leave records behind. And basically what we're after here is if you are a trustee and you sort of cease to be a trustee, you still have some obligations. And if you don't fulfill them, if the Ministry of Health or our office or somebody has to kind of come along and, quote, clean up the mess, then you as a former trustee would be obligated to cover the costs of that. Again, if you collect it, then you must protect it.
Item P deals with deceased individuals. Though personal health information also includes its information with respect to an individual, whether living or deceased, there are very limited provisions in HIPAA that provide that authorization to use or disclose personal health information if the individual is actually deceased. And that makes sense because you're no longer providing diagnosis and treatment and care to the individual. But we do believe that there are some legitimate purposes that are not listed. And so we've added a number of those that include the following. that the information can be provided without consent to the coroner, law enforcement, funeral directors, next of kin, or anyone else for the purpose of identifying the individual. Secondly, if it's for instance, family members, next of kin, that they reasonably require it for their own health care needs. The third, if it relates to a claim under a policy of insurance. The fourth one is if, in fact, it's just to let somebody know that somebody has passed away. And lastly, for the purposes of determining or carrying out the individual's wishes in relation to the donation of the individual's body parts, tissue, or bodily substances. And we recently also made this proposal in front of the Legislative Assembly's Standing Committee on Human Services that held public hearings on organ and tissue donation in Saskatchewan. We made this submission on September 6th. But the other part of this too is, if you look at subsection 27.2, there are circumstances in which the expressed wishes of the patient when they're alive should be taken into consideration. We think the same should survive after death. So we've also made that proposal in the event that the individual is deceased.
Next is item Q, and it deals with other uses and disclosures. And we're really into clarifying secondary uses or secondary disclosures and making sure that the legislation kind of matches up to what people are doing now. And basically what we're kind of saying here is that information could be disclosed when you're dealing with the donation of body parts, links into what Diane talked about when you're deceased. Secondly, we find, for example, in a hospital setting that there's a lot of training going on, whether it's students, sometimes volunteers, all part of the system. And really, you know, if somebody takes a group of students into a ward and there's a patient there, not long they're disclosing that person's personal health information. But in another sense, it's very necessary for the training of those individuals, sort of a case basis. And finally, allowing use of this information for error or risk management. Obviously, we want our system to operate well, not make errors, and reduce risks.
Item R is user logs, which builds off that definition that I introduced on item B. The slide specifically deals with definitions. So when it comes to user activity logs, we know they're already in use. They're built into a lot of the newer systems and not necessarily the legacy systems. But this proposal requires trustees to create and maintain records of user activity in the cases where they can, and maintain these records for at least 3 years. Also, auditing will be required, and it's clarified that no fees should be charged to an individual when they request a copy, which I also believe is standard practice in the system now.
Off to item S, which deals with notification of breaches. At the moment, trustees report breaches to our office, and we refer to that as proactively reporting the breach. There is nothing that says a trustee must report it. If you look at the jurisdictions in North America, provinces and states, I would say bit by bit, jurisdiction by jurisdiction, they're moving to requiring a mandatory reporting of breaches. And again, when you're dealing with personal health information, whether the breach comes from the outside, a hacker or whatever, or whether it comes from the inside, snooper who had no need, no reason, no authority to have to know. If it's my personal information, then don't I have a right to know that someone has been in there inappropriately? And our conclusion, and many jurisdictions' conclusion, is that I do have a right to know. So this basically would say, if a breach occurs, doesn't matter how it happens, if a breach occurs, that you report it to those affected. You know, and I give 2 examples. If it's cancer or HIV and I haven't told my family, and all of a sudden my information is breached, you know, I may want to take corrective actions to tell my family or my friends. I also would report it to our office, and if the breacher, the snooper, belongs to a professional body, report it to that professional body. Now, this proposal is slightly stronger than the provision you'll see in Bill 30 in front of the House right now. But what Bill 30 says, that if there's a breach on personal information, you need to report it to those people that are victims. It is silent on reporting it to our office, but we think if it's reported to the victims, that we'll in due course know. So this is our attempt to sort of deal with and have more parameters around snooping and external breaches too.
Item T is privacy impact assessments, or we lovingly refer to as PIAs. HIPAA presently doesn't contain any provisions that require PIAs to be completed, nor does it require those to be provided to our office for comment. So what we are recommending is similar to what we did in the FOIP amendments in its time to update, but we've made it very clear that it's not in every case, every time there is some sort of a minor change. And this is the language that we're using. A trustee must prepare a privacy impact assessment that describes how any proposed substantive changes to administrative practices and information systems related to the collection, use, of disclosure of personal health information may affect the privacy of the individual who is the subject of that information, and that PIA would be provided to our office for review.
We're off to item U, and as you can see, some of the proposals help citizens and some help trustees, like the abandoned record one. This one assists our office. Basically, we have been doing reviews in the area of fees and a few other things where it doesn't explicitly say in the Act that we can review those areas. And we've just included this to sort of clarify and I suppose bring the legislation kind of in sync with what we have been looking at and what we have been reviewing when it's brought to our attention.
Item B is powers of the commissioner, and it's taking what the commissioner just said and building on it a little bit more. When it comes to reviews and investigations, for instance, in our acts, in FOIP and LA FOIP, and even in HIPAA, there's clear rules around what can happen in a review, not as much information around an investigation. So when in doubt, it's always better to have clearer language, more explicit language. So what we're proposing is a number of things. And by the way, in the HIPAA amendments document, you can find these on pages 62 to 65. So the first is that the commissioner will have the same powers in an investigation as in a review, including the right to enter premises, which is already explicit in FOIP. Secondly, that the commissioner has the right to set his or her own procedures, which we already do, and that the commissioner has the discretion to disclose information, and this is a brand new one, to any person when it's necessary to protect the privacy, health, or the safety of an individual, or when it's in the public interest.
We're off to item W, which is additional offenses. A number of years ago, the Legislative Assembly did introduce some amendments to HIPAA, which added some offense wording, mainly aimed at creating an offense that would deal with the snooper. That is in force now. There's been no cases under it yet, but it is there. And this just kind of builds on that a little bit and basically proposes an amendment that says if someone collects, uses, or discloses information contrary to the Act, then that's an offense. And it also goes on to say that if a researcher contravenes basically the Act or the information sharing agreement, that would be an offense. I think as we get into, again, the data analytics, the analysis, that type of thing, the pressures and the need for research, there may be more research. And if it's research for a good and laudable purpose, that's great. But then once the researcher has the information, we don't want carelessness or any cavalier attitude. And if they are totally responsible, then they may just get charged with an offense.
Item X is review of HIPAA. HIPAA's been around since 2003, so 13 years later, and we haven't had a legislative review of HIPAA. What we are recommending is, as what we did with FOIP and LA FOIP, is that it should be regularly reviewed. And we've included specific language so that it hopefully will happen every 5 years.
Off to item Y, interjurisdictional investigations. From time to time, not often, an issue or a problem will arise and it affects both two provinces. In our instance, obviously, Alberta or Manitoba. It could be others, but they first pop into your mind. And also Lloydminster pops into your mind where, there'd be an Alberta health region and a Saskatchewan health region and trustees that probably have a foot in each province. There's also a general obligation that our investigations are conducted in private and we should only disclose the amount of information necessary to to do our job. So this would really give us the authority to exchange information with, say, Alberta, if we were doing a joint investigation.
So I have the pleasure of doing the last slide, item Z or Z, whatever your preference is, whistleblower protection. So with government institutions in Saskatchewan and government employees have whistleblower protection under the Public Interest Disclosure Act. HIPA doesn't have the same for employees of trustees. So what we're proposing is, and we've looked at both British Columbia, Newfoundland, Labrador, and we have proposed changes that would offer that protection to trustee employees.
So in closing here, we have given you a brief summary of the proposed amendments. We expect that government in due course would do a consultation and would study these amendments and take input from all the many stakeholders in the health sector in this province. And eventually we would hope that it results in amendments that go to the Legislative Assembly. Now, if you wish to see the detailed amendments, you can see them on our website. And our website is www.oipc.sk.ca. We also have a detailed document that goes into more detail, and it's almost 70 pages long. And it cites a lot of the legislation from other provinces or territories. And really, that has sort of been the key for us. I think I referred to the data matching one and sort of copying the Alberta legislation. And in many instances, we've sort of looked at what's the most recent, which province has moved in this area last, and have they come up with progressive legislation. So the detailed summary is on our website also. If you want to know what we're thinking about or working on at our office, we would really ask that you join us at Twitter. We're at Sask IPC. We're usually tweeting almost every day of something we've posted, a blog, a new guideline, or an interesting case that has come out of Ontario, BC, or Alberta, or that has some relevance to Saskatchewan. So please follow us on Twitter. If when you get back to your office you have thoughts on any particular amendment or proposal that we've talked about, the last two sessions, we in fact have invited emails to Diane for people that thought maybe we should look at something a little more. And we certainly don't mind doing that, and hopefully we'll be an active participant in any consultation process that the government opts to take on. So again, thanks for coming and being in the room. For those of you that are listening to this online, thanks for attending. If you have any questions when you hear this online, please email us or give us a call. Thank you very much.